am going to I'm going to start my timer because this is it's a one credit program. I only need to speak for 50 minutes. I do anticipate it going the full 50 minutes. If there are questions, please, I encourage everyone to put your questions into the chat pane. If there's time at the end, I'll do my best to address whatever questions I can, but I promise that if I can't get to them during this presentation, I will follow up post the presentation. And again, I just want to thank both Richard and Diana for setting up this program. We value, First American values its relationship with Judicial Title. They are one of our premier agents in all of New York State, and we truly value the partnership that we have with Richard and his entire team. So with that, I'm going to start my timer. And we are going to talk about who has the power, entities, and fiduciary duty. Now, I'm going to preface this by saying some of the items that we're going to discuss may seem somewhat basic and common sense, a common sense approach, and they're meant to be. But I will tell you that in title insurance, when we're going through the process of insuring a transaction, whether it's a sale transaction or a mortgage transaction, authority is one of the key elements that we really focus on. And I will tell you that this is a topic that while I present on it for attorneys all the time, for our agents, our home office presents to us regularly, multiple times during the year, to kind of just remind us why we need to focus on authority and what we should be looking for, and the pitfalls that are out there that can really cause problems if we're not following proper protocols. So with that, I'm going to jump right in. Okay, so what is corporate authority? So this presentation, we're going to use corporate authority in a general sense of the ability of any artificial person to act through their respective fiduciary. The issues and concerns that we're going to discuss will apply generally to all artificial persons, including but not limited to corporations, LLCs, trusts, estates. Yeah, that was the last one. So I actually, before I go any further, I just want to preface this presentation with just one more statement. The reason this is so important to us, to the agent that you work with, judicial, to the underwriter, the claims that we see come through, and unfortunately we see claims on a regular basis, that there's a real need for title insurance. I unfortunately get to see every claim that comes through, and I can tell you that many of them fall into two main buckets. Fraud is a significant area where we see a lot of claims, but right behind it, and just as important, are claims that revolve around authority, challenges to a transaction because someone is claiming that there was not proper authority. So I just kind of wanted to preface it before I go on. So fiduciaries. What are we talking about when we talk about fiduciaries? We're talking about corporate officers and directors. We're talking about managers of limited liability companies. We're talking about trustees of trusts, executors and administrators in estates, and agents under powers of attorney. Okay, so why do we care? Why do agents, why do title insurance care so much about authority? So I'll give a little bit of background. I'm going to start with the Alta 2021 owner's policy. That's our newest version of owner's policy. It went into effect on October 1st of 2024. Previously, it was referred to as the 2006 policy. And the owner's policy provides the following. So covered risk 2A2, a defect in the title caused by the failure of any person or entity to have authorized a transfer or conveyance. Now, just remember, these are direct covered risks under the fee policy. Covered risk 2A sub 3, a defect in the title caused by a document affecting title not properly authorized, created, executed, or delivered. And then lastly, covered risk 1, title being vested other than as stated in Schedule A. Now that's the owner's policy. The loan policy, again, we are now dealing with the Alta 2021, but the former policy was the 2006 version. Loan policy provides covered risks 9B and C, the invalidity or unenforceability of the lien of the insured mortgage upon the title, due to the failure of any person or entity to have authorized a transfer or conveyance and or the insured mortgage not being properly authorized, created, executed, or delivered. Okay, so you can see the main points that they're focusing on, right? Authorization to create, execute, and then deliver the document that will ultimately be insuring. So for today's purposes, we'll focus on insuring of a deed and insuring of a mortgage. So I like to break this into a pyramid, basically. And we're going to start from the bottom up and build. And we're going to start with establishing corporate status. Now, remember, when I use the term corporate, it's an all-inclusive term. I'm talking about corporations, LLCs, trusts, estates. So just for simplicity's sake, I'm just going to use the term corporate to refer to all of those entities. Next layer, corporate powers. And then right at the top, the corporate acts. And so we're going to start with the foundation and work our way up. Okay, so proper foundation of corporate authority builds from the bottom up. Without proper status, there are no valid powers. Without valid powers, there can be no authorized acts. And finally, without properly authorized acts, the whole transaction may be voidable or just outright void. So let's start, let's start with corporate status. And when we talk about corporate status, we're going to focus on three elements. The first one is due formation / due organization, continuing existence, and then good standing. So let's start with due formation. So what's the basic question here? Has the entity met the statutory requirements for being formed or organized under the laws of its domiciliary state? Now remember, we're not just going to be talking about entities that are formed in New York. More often than not, when we're dealing with corporations and LLCs, we find that we're dealing with out-of-state entities. But the items I'm going to touch on, they will affect both New York State entities and foreign entities. Now, we have to be careful when I refer to foreign entities. I'm referring to non-New York State entities, so entities formed in other states within the United States. I will have some reference to foreign entities that are outside of the United States, and we'll touch on those also. I'm going to do the best I can in the time that we have, because honestly, we could probably take any one of these subtopics and spend 50 minutes speaking just on that topic alone. Okay, again, so has the entity met the statutory requirements for being formed or organized under the laws of its domiciliary state? What do we need to do? We need to obtain and review copies of the entity's organizational documents. I mean, that's where we start. We ask for the corporate documents, the LLC operating agreement, the trust agreement, the last will and testament, or power of attorney, if that's what we're dealing with. And we always ask the question, are they consistent with if we're dealing with a non-New York entity, are they consistent with the domiciliary state law? For foreign non-U.S. entities, it's important that the documents be translated and certified. I can't tell you how often we get non-U.S. entity documents that are in a foreign language. And while I can do pretty well if they're in Italian or maybe even in Spanish, beyond that, we're going to need someone to translate and certify what those documents state. So let's move on to existence, right? So what are we talking about when we're discussing existence? Does the entity still exist, or has it terminated by any of the following events or acts? Expiration by terms of the organizational documents, merger or conversion into a different entity, voluntary or involuntary dissolution. Here again, we're going to review the corporate formation documents, including all amendments, to see if the entity has expired by its terms. We're also going to be looking to see if the entity is in good standing. Now, here we're going to be looking for a certificate from the Secretary of State, which represents that there are no deficiencies in the entity's filings. This is going to vary from jurisdiction to jurisdiction. And I also want to point this out. The certificate is not always dispositive of the entity's continued existence. You might actually be able to get a certificate of good standing out of the Secretary of State, but the entity's own organizational documents might have a triggering event which effectively terminates the existence of the entity. So a good standing certificate alone will not be dispositive. That's why we want to see both the organizational documents and the certificate of good standing. All right, so let's talk about the conditions of certain entities. Let's say you are dealing with a dissolved entity, and for now, we'll kind of focus on corporations and LLCs, right? So if you find that you do have an entity that's been dissolved, whether voluntarily or involuntarily because they haven't complied with some requirement of the state that they're located within, right? We see this all the time where the Secretary of State will file a dissolution. Does that automatically mean that it's a hard stop and you can't proceed? What do we do if we have a dissolved entity? Well, first question we're going to ask is the intended transaction an act of winding up? So what do I mean by that? Are they basically, do they have one asset left, and are they just trying to wrap things up and close out business, and that'll be the end of it, right? If that's the case, you won't necessarily have to reinstate the entity into a good standing status. Now, there are some exceptions to that. You know, I mentioned before that we're going to just focus on the ensuring of the transfer of deeds and mortgages. But you might have a scenario where being you're being asked to ensure a transaction where there is a contemplated transfer of the shares in the corporation or the membership interests, not the actual underlying title to the property. If that's the case, if you have a transaction that involves the transfer of shares or membership interests, well, then the entity has to be reinstated. It can't be done as a winding up of the affairs. Okay. Um, if it is a winding up, and again, we're going to look at a number of different factors here. An entity that comes to you and, well, I'll just give an example, has 7 or 8 different properties, and they are no longer in existence because they failed to either file tax returns or biennial statements in New York State, and they've been dissolved by the Secretary of State. Well, if they come along and they've got 7 or 8 different properties, we're not likely going to take a winding up of the affairs approach. In that instance, most likely we're going to insist that the entity be reinstated before we proceed. But if it's just, as I stated before, one property coming in, they want to get rid of the property, close up the books and records. We can do it as a winding up of the affairs. We'll have the deed state that. But here again, you're going to need to establish certain items. You're still going to need to review the corporate records and books. You're going to need to establish who the shareholders are, who the officers are. You can't have just one person come along and say, well, I'm the sole shareholder, entity's been dissolved, and I'm going to give you an affidavit stating that this is a winding up of the affairs. We effectively have to go through the same process. We have to establish we have to review the organizational documents to establish authority, establish who the shareholders are and who the officers are. So one of the problems that we come across fairly often is that when we ask for these organizational documents, and this is especially the case where you have an entity that may have been dissolved, and it may be many years. We've seen scenarios where an entity's been dissolved for 10, 15 years, but they've continued to hold title in that entity. They no longer have any records, no bylaws, no certificate of incorporations. Very hard to establish who the proper parties are when you don't have those bylaws, when you don't have the certificate of incorporation. So what are other avenues for us to be able to establish who the proper parties are, who the authorized parties are? We're generally going to ask for tax returns, and we'll want to see multiple years. We generally will not rely just on the last year or 1 year's worth of tax returns. That presents significant risks. It really opens up transactions to potential fraud. We understand that sometimes mistakes happen and entities lapse. But we would still expect, especially on commercial transactions, that the parties are still filing regular tax returns. And that's going to be very helpful because the tax returns will, in fact, list, for a corporation, they're going to list who the shareholders are. For an LLC, they will list who the members are. And we can get pretty comfortable with those documents and establishing who the authorized parties are. Now, one other item that we have to consider, we come across this often, death of a shareholder. This gets a little trickier. This can be the case where you have either a dissolved entity or an entity that's in existence and good standing. We're generally going to need to see an estate, some type of estate proceeding to establish the devolution of the shares to either heirs or devisees, specific devisees, if we're dealing with a will. Absent there being an administration or an estate proceeding, it's very difficult to move forward if the parties come to you and say, well, the shareholders or the members are all deceased. All right, so we've touched on corporate status. We're going to move on to the next layer, which is corporate powers. And you'll see this is where does the power come from? So we're going to start off by checking the laws of the governing jurisdiction, right? We need to know what state the entity was formed in. Then again, and again, some of this is going to be repetitive. We're going to ask for the organizational documents. We'll want to see the bylaws if it's a corporation. We'll want to see the operating agreement of an LLC. If it's a partnership, we want to see the partnership agreement. And if you're dealing with something other than a corporation, LLC, or partnership agreement, if you're dealing with a trust, obviously we will want to see the trust agreement, and we're going to get deeper into this. If it's an estate, we're going to want to review the last will and testament to begin with, obviously, and then the probate proceedings. And if you're working with the power of attorney, we're going to want to review the power of attorney. All right, so how do we determine the powers? So we're going to start with reviewing the statutory provisions that govern the entity. And so to do the statutory provisions, and again, we're going to distinguish between the statutory provisions and then the powers that the actual organizational documents might provide. Sometimes they will align, sometimes they will not. But we're always going to start with the statutory provisions, and we're going to ask, do they authorize the entity to convey or mortgage the premises? Or are there conditions precedent to exercising of the power? So for corporations, the relevant New York statutory provisions are Business Corporations Law Section 615 and 909. These sections effectively provide the following. They require a 2/3 vote to approve a sale or a lease, if that's what we're dealing with. I know I spoke about deeds and mortgages, but we can throw lease in there as well. So if it's a sale or lease, and this is key, not made in the ordinary course of business, right? And so what do I mean by that? Well, let's take the example of a sponsor who's selling off newly formed condominium units. That would be deemed in the ordinary course of business, right? That sponsor selling off those units, ordinary course of business. What might not be ordinary course of business? A corporation that owns one piece of property that it runs a business out of. Let's say it's a printing company, and they're closing up their business and selling off their sole asset. That would not be something in the ordinary course of that company's business. That company's business would be it's a printing company. So selling off real estate, and certainly their only real estate asset, would not be in the ordinary course. If it's not in the ordinary course, you're going to need a 2/3 vote of the shareholders or members if it's an LLC approving that sale or lease. Okay, so now there are some exceptions. A majority will work if it was formed, if the entity was formed after February 22nd, 1998. Anything before that, you need 2/3 approval, unless the certificate of incorporation provides otherwise. So you can have a pre-February 22nd, 1998 entity that has a certificate of incorporation that provides only for majority vote, and that will work. Now, here's where it's important, and we're going to touch on this as we continue on through the program. Just because something may be authorized pursuant to statute does not automatically mean that you will have a title insurer that will agree to insure that transaction. I'm going to leave that as a general statement for now, and I'm going to get into specifics as to why that might be the case and in what scenarios you will most likely find that that will be the case, i.e., even though you have 2/3 or you have a majority if that's all required, you may still find yourself in a position where a title underwriter informs you that they are not prepared to insure the transaction. Okay, so if the present transaction consists in whole or in part of the making of a mortgage. So we were talking about deeds and leases. Now with mortgages, there needs to be compliance with Section 911 of the Business Corporation Law, and that one's a little bit different. That requires a resolution of the board of directors of the corporate mortgagor authorizing the making of the mortgage. And we're going to delve a little deeper into this. A resolution alone is not going to suffice. You're also going to need to show that you don't need the consent of the stockholders of that corporation to make the mortgage. Now, here again, how do we establish that? A review of the organizational documents. We're back to, we need to see the certificate of incorporation. We need to see the bylaws. Or if it's an LLC, we need to see the operating agreement. We need to be able to establish that you don't actually need a vote of the shareholders or membership holders to authorize that mortgage. Okay, we're going to continue on. We're still on the middle tier of the pyramid, corporate powers. We're going to review the organizational documents of the entity. Do they authorize the entity to convey or mortgage? Are there conditions precedent to exercising that power? Well, let's go into some specifics, right? So, organizational documents, we've already touched on: certificate of incorporation, bylaws, LLC operating agreement, trust agreement, last will and testament, probate or administration letters, power of attorney. So now here's where I want to touch on some of the parameters that we work within and many of the red flags that we look for. Okay, and now again, still focusing on middle tier of that pyramid, corporate powers. All right, so we're always going to start by focusing on the state where the entity was formed. Terminology and requirements will vary from jurisdiction to jurisdiction, but there are some basic common principles and red flags to be aware of. This one's common sense, straightforward. Do the documents appear facially valid? Are the parties advising that there are no bylaws or operating agreement? Now, I will tell you that we unfortunately, we have this situation come up very often. Especially so when you're dealing with a closely held corporation, um, family held properties. Unfortunately, the parties don't always, while they file the initial filing documents, whether corporate or LLC, they don't always follow through and actually create and execute either bylaws or an operating agreement, and that creates problems. I already touched on one way of dealing with this. We will be looking for tax returns. That is going to be helpful. They might not be sufficient on their own. Another red flag, and this is now going to tie back to the statement I made earlier that even though from a statutory standpoint, you may only need a majority or a two-thirds vote. There might be scenarios where even though you have that majority or that two-third vote, you might find yourself in a position where an insurer tells you, we are not prepared to insure. Why? So if you and more often than not, this is going to fall in the category of not in the ordinary course of business, right? And you see that you're not getting all of the shareholders or all of the members, or if it's a trust, all of the trustees signing in, signing on and consenting. It's a red flag. It's especially a red flag where you have a deed in lieu transaction. So very quickly, again, I said any one of these topics I could probably sidetrack and spend 50 minutes on. A deed in lieu of a foreclosure is a scenario where an owner is basically agreeing to turn over the property to a lender because the property is in distress. Mortgage may be in foreclosure. Owner likely believes there is no equity in the property, and rather than going through a long, drawn-out foreclosure process, may approach the lender and say, "Hey, look, we will turn over title to the property if you release us from the obligations of the mortgage." So deed in lieu of foreclosure. Now, here's where it really gets tricky, because if you have an entity, whether it be corporation, LLC, or a trust or a partnership, and you don't have all of the members agreeing to that deed in lieu, the likelihood is, and I say likelihood because there will be exceptions. We're for the most part speaking in generalities. There are going to be exceptions in almost every transaction. It will be fact specific to the transaction. But what are we worried about? So let's say you have a corporation that's made up of 5 members, and you've got 4 out of the 5 that are agreeing to the deed in lieu of a foreclosure. But that 5th member is not agreeing to sign off. Now, clearly, you've got 4 out of 5. You certainly have a majority if that's all that's required, and you will certainly have 2/3 if you need 2/3. But why might a company still say no, unless you get a unanimous 100% sign off, we're not going to insure? Well, there are so many different variations that could present themselves. It's very possible that the parties that are agreeing to the deed in lieu and are agreeing to consent, it might be the case that they may have personally guaranteed that mortgage. And so they may have different motivations for handing over that deed in lieu of being released from their obligations than maybe that 5th member who might not have signed a personal guarantee. And even though we might, and when I say we, I'm referring to we, the title company, were we to insure this type of transaction, with 75% of the members signing off. The likelihood is that we would prevail if that fifth member brought a lawsuit. And here's a statement I'm going to make. You may have heard it before. Our mantra really isn't whether we think we can win the fight. Our mantra is we don't want to get into the fight to begin with, because fighting that fight costs money. Even if it's just defense costs, even if ultimately we are successful, it's very possible the defense costs alone could exceed the amount of insurance under the policy that was issued. So again, red flag, if you're dealing with a distressed property and you're not getting unanimous consent, be prepared that you might run into a situation where an underwriter may not be willing to insure that transaction. Okay, have there been recent changes to the organizational documents? This one's an important one, and I want to just move ahead one more. Has there been a change in the composition of the entity? Now, the reason we look for these items is that sometimes behind the scenes, we may be dealing with a mezzanine foreclosure. Again, this is one of those topics where I could get sidetracked and spend an hour on it. But mezzanine foreclosures happen very differently than judicial foreclosures. So a mezzanine foreclosure is basically a shareholder who may have pledged their shares in an entity, and there's no mortgage that gets recorded with a mezzanine loan. The only thing that really gets recorded is a UCC1, and the process to foreclose, if there's a default on a mezzanine loan, is non-judicial. Because it's non-judicial, it makes it very, very hard to insure. In fact, I will tell you that if we know that title is coming out of an entity that has gone through a mezzanine foreclosure, it is very unlikely that you will be able to insure that transaction unless you can get all of the members, and I'm talking about the current and prior members, signing off and agreeing to the transfer. And then lastly, what are we looking for? When you have documents that maybe are missing or incomplete, might not have been executed properly, if we have counsel involved in a transaction that we're familiar with, that was involved in the actual formation of the entity and can give color to what happened and what the current status is, that is definitely going to be something that we will take into consideration and will help get a deal done. So some additional consideration. Diligence in corporate power is particularly important when dealing with entities other than traditional business entities. So what are we talking about here? Charitable organization, nonprofits, just real quick on those. More often than not, those are going to require either AG or court approval. Churches and religious organizations, they are almost always going to require court approval. There are some statutory exceptions. Governments and quasi-governmental bodies. Here, I want everybody to think of also foreign governments, which trigger the Foreign Missions Act. If you have a foreign government that's coming in and looking to purchase property as a foreign mission, they must there is a very specific process that they have to follow, and they need to go through the Secretary of State and get approval for that. So again, something to keep in mind. Indian tribes and tribal entities. Again, if title is coming out of a Native American tribe, they don't have, okay, so the key here is that you're not able to sue an Indian tribe or federally recognized tribal entity. Here again, you need to get the government involved, and there needs to be certain approval. So if you are dealing with lands that are coming out of a Native American tribe ownership, just be aware there are specific requirements that go along with that. And then last one, non-U.S. overseas entities. We've all seen all of the recent efforts to enact legislations which restrict the purchase of U.S. land by foreign entities. Again, just something to be aware with. It's going to vary from jurisdiction to jurisdiction. Work with your underwriter if you're dealing with a non-U.S. overseas entity.
I'm just popping in to give the course code for the lecture. The course code is POWER. The course code is POWER. Thank you.
Thank you, Diana. Okay, so series LLCs. I'm just real quick on this one. New York does not recognize series LLCs. I will tell you that many other states do, Delaware being one of them. If you have a transaction that involves a foreign series LLC, contact your underwriter as early on in the process as possible, because there are certain protocols that we need to follow, certain documents that we need to look through. The key here is I just want everybody to be, if you come across a transaction that involves a series LLC, call your underwriter and start the discussion very early on in the process. All right, so that brings us to the top tier of the pyramid, which are the corporate acts. And here we can really break them down into three subcategories. One is their due authorization. Two is their due execution. And three is their due delivery. So let's start with due authorization. So have the persons in control of the entity taken the necessary action to approve execution and delivery of the deed or the mortgage. What it takes to authorize an act varies by entity type and transaction type. We've actually kind of hit on most of these already. Here again, we're back to reviewing the organizational documents of the entity to determine what steps must be taken to authorize a conveyance or a mortgage. You're going to need a written resolution or consent certified by the secretary or similar officer of the entity authorizing the conveyance or the mortgage. This one probably I could have put under red flags. Just be alert for major decision provisions that you find in documents. You will come across this quite often. These major decision provisions usually either require supermajority votes or, in most cases, unanimous consent. So just be on the lookout for them. Due execution. So what are we asking here? Was the deed or the mortgage properly executed? And again, this is a basic common law requirement to establish the effectiveness of any conveyancing instrument. For purposes here, we're really asking, was it executed by the authorized person? Again, you're going to review the organizational documents and you're going to see if they specify who the authorized signatories are. Then we're going to look to the written resolution or consent. And again, we're going to try to establish who does it specify has to sign the document. It's very important that they match up. Lastly, if you're dealing with a trust, will, power of attorney, we need to review those documents. Now, again, sometimes we get pushback on trust agreements, and the reason we get pushbacks is parties who are concerned about confidentiality. We can work with redacted documents to an extent. As long as we can establish the authority and the power, there are scenarios where we can work with redacted documents. What doesn't really work in New York, and I'll tell you in other states, there is statutory provision for it. Certificates of trust. So quite often we'll have a certificate that's provided to us by, usually comes from counsel, that basically seeks to tell us, yes, the trust authorizes this, and and this is the person that it authorizes to execute. I will tell you, unless there are other factors that we can get comfortable with, a certificate of trust alone will generally not work in New York. All right, third part of the corporate acts, due delivery. Was the deed or the mortgage properly delivered? Here again, that this is basic common law requirement for effectiveness of a conveyancing instrument. Question here is, was it delivered by the authorized person? Here, this is going to be a little bit repetitive. We're again going to be looking back to the organizational documents and the resolutions to determine who they specify as the party that is authorized to both execute and deliver. They are usually one and the same. And it's important we verify that the delivery is unconditional, or that any conditions to delivery, breaking of escrow have been met. Generally, in a commercial context, this is going to involve checking our closing instructions, but it's important that the delivery is unconditional. If you have conditions, or if you haven't broken escrow, and you might meet all of the other elements, authority, execution, and then you get the delivery and you deliver it in escrow with conditions, and then the party that was authorized to deliver it, I'll use the example of someone passing away. If it wasn't delivered before the person passes away, that delivery is going to be defective. All right, so let's talk about entity chains. I know we're running out of time, but I'm going to go a little bit quicker. Entity chains. I want to throw up an example. Now, I will tell you, we see entity structure charts all the time. And this one is a very simple, straightforward one. I will tell you, I've seen many that have up to 15 to 20 different layers that split off into 20 to 30 different directions. This one's pretty straightforward. You have ABC Corp, that is the title owning entity. We're going to ask for the organizational documents of ABC Corp. You review them. They reflect that ABC Corp is owned 50% by Main Street LLC, 50% by Mary Smith individually. Individual, not a problem. Mary Smith can act on behalf of herself. Main Street LLC. The only way we can figure out who can act on behalf of Main Street LLC is for us to ask for the organizational documents for Main Street LLC. You get those documents. Now you see that Main Street LLC also owned 50% Realty Corp, 50% John Smith. Not a problem with John Smith. John Smith can act on his own behalf. Realty Corp, what do we need to do? We need to ask for the organizational documents for Realty Corp also, because we need to know who can act. We need to be able to establish who can act at each level of the structure. Now, here again, I will tell you, every transaction is going to be fact specific. There will be exceptions. You might have entities that sometimes have a 1% member that is designated as a managing member with all of the power. In those instances, more often than not, we can get comfortable with the transaction as long as it's in the ordinary course of business. The exception is if it's not in the ordinary course, if it's a deed in lieu or a property in distress, and you have one party that is maybe just a 1% owner but has managing member powers. I will tell you, in a distressed property, situation, that's going to be a problem. Okay, some additional considerations, factors that we will look at. Is it a bona fide transaction for full value? Again, here, is it in the ordinary course of business? If it's not, if it's a distressed property, we are going to look at it a lot closer, and we may be asking for a lot more documentation. We just talked about that. Again, all or substantially all of the assets. If we have a scenario where it's a condominium regime and it's a sponsor selling off units, we generally work off a resolution, and we're not looking for a vote of the shareholders. But if it's all or substantially all of the assets outside of the ordinary course, that's going to, at a minimum, trigger a 2/3 requirement or majority if that's what's provided for in the operating agreement or bylaws. But there again, we're going to look at the nature of the transaction. Are there dissenting shareholders? This happens all the time. And this kind of brings me back to, even though we may have the statutory authority on our side, we might not always agree to insure, because if you have a shareholder that is making clear that they are objecting and they're not going to join in, the costs of defending that type of challenge can be significant. Also, powers and authority can change. Prior transactions are not always a safe harbor. I just bring this up because sometimes you'll have an entity that does multiple transactions, whether it's multiple sales or multiple refinancing. Don't be surprised when an insurer asks to see documents more than once, because again, documents change, shareholders change, people come in, they come out, ownership structures change. So the key here is prior transactions, not always a safe harbor. All right, I know my 50 minutes has expired, Diana. I'm gonna end it on this slide dealing with foreign entities. If we have questions, if you can put them together for me afterwards, I'm happy to address them after the presentation.
You got it. I copied all of the questions, so I'll send you anyone who asked a question. I'm going to send them to Tony with your email address, and he'll shoot you an email with the reply.
All right, perfect. So we're going to end with this slide, foreign entities. We've kind of touched on it a little bit already. Again, we're going to be looking for a good standing certificate. An important point here is that foreign entities can have no greater powers than domestic entities. So if a New York entity is not able to do something in New York, a foreign entity will not be able to do it, regardless of whether in their home state they have the power to take whatever action they're proposing. Again, we touched on true foreign entities, i.e. non-U.S. entities. Just remember, we have a Foreign Missions Act. If you have a scenario involving a foreign country, get in contact with your underwriter at Judicial as soon as possible. We will help walk you through what needs to be done. There is a very specific process that needs to be followed with foreign countries, foreign missions. And if it's a foreign entity, meaning U.S. foreign entity, there may be scenarios where we're going to be looking at. Sorry, we may request an opinion of counsel from someone admitted in that foreign jurisdiction. That really is going to be transaction specific, fact specific to whatever act the entity may want to take in New York. If it's something out of the norm of what we're used to seeing, we will on occasion ask for an opinion of counsel from an attorney within that home state where the entity is located. Okay, so with that, I'm going to thank everyone for having joined this presentation. I want to thank Judicial again, and any questions that were submitted, Diana will send on to me. I promise I will put together answers and get them out as quickly as possible.
Great.
So,
Thank you so much for a great CLE, Tony. We appreciate it. It's always a pleasure to work with you. Thank you everyone for coming. I will resend all of the material this afternoon just in case you did not receive it. And everyone will get their certificates by next week. So have a great rest of your day, everyone. We'll see you in July.
thank you, Diana.